This hearing is entitled Oversight of the SEC's Division of Enforcement. I recognize myself for 4 minutes. There is nothing more important for this subcommittee to do than oversee the SEC. I look forward to the full committee bringing the chair of the SEC before the full committee. I would hope that that would happen either at the subcommittee level or at the full committee level several times each year. But oversight of the SEC is also enhanced by bringing before us the division director of the largest division of the SEC. The Securities and Exchange Commission oversees $100 trillion in securities investments and reviews disclosures of 7,400 public companies, including more than 4,000 exchange-listed public companies. The SEC has an annual budget of $2 billion, supporting 4,500 employees across both the headquarters and the 11 regional offices, the most important of which is now in my new district in Los Angeles. The agency's largest division is the Enforcement Division, with some 1,366 employees, representing a quarter of the SEC staff. The division is responsible for enforcing our securities laws. In 2021, the SEC filed some 434 new enforcement actions, representing a 7% increase. As the chair of the SEC, Gary Gensler, pointed out, the purpose here is to discourage misconduct before it happens. Today, the division faces new challenges in the form of cryptocurrencies and other digital assets. The combined value of these digital assets hit $3 trillion at a peak, from which it has declined. In response, in 2017, the SEC established a crypto assets and cyber unit within the Division of Enforcement. That division has brought some 80 enforcement actions related to fraudulent and unregistered crypto asset offerings and platforms, resulting in monetary relief totaling $2 billion. This is by far the most of any federal or state regulatory body. Obviously, there have been recent downturns in the value or purported value of crypto assets. In particular, their enforcement actions depend upon the definition of the word security under a relatively ancient Howey test. The division has determined that XRP is a security and is going after XRP, but for reasons that I'll bring up in questions, has not gone after the exchanges where tens of thousands of illegal securities transactions were occurring. The division faces a number of longstanding challenges. Today, we're considering a number of important bills that are listed for all of the members of this subcommittee and are being considered in this hearing. There is no federal statute defining insider trading. I know Mr. Himes has a bill designed to do just that. And, of course, the Newman decision narrowed the definition somewhat of insider trading. Another issue for us to confront is the maximum civil monetary penalties, which some bad actors simply regard as doing a cost of doing business. Recent decision in the Fifth Circuit has called into question the whole use of using administrative law judges, which is the primary method of enforcing our securities laws. The court found a number of problems. Some are constitutional and would require a change in practice if that court decision, which is now in appeal to an en banc review, is upheld. But other concerns of the court are about the inadequate standards that the Congress has put into the statute, and we need to correct those by legislation, probably even if the court decision is successfully appealed. Finally, we're looking at the SEC's use of waivers where bad actors admit to wrongdoing but then don't face the full penalties. With that, I recognize